The tragic shooting death of Trayvon Martin is raising yet more legal questions. The 17-year-old was shot in a housing development in Florida. The neighborhood watch captain, George Zimmerman, confessing to police he shot and killed Martin, claiming, though, self-defense. Now, that claim has sparked nationwide controversy, and now legal experts are asking whether the homeowners who live in the development could be subjected to a civil action as well. How would that play out in court? Let's ask Kisha Hebbon, former prosecutor, Joey Jackson, who is a defense attorney. Good to see you both.
Good
Kisha,
to see you, Greg.
This neighborhood watch group established, organized, and operated the watch group.
Right.
So if George Zimmerman is held negligent, let's say, somewhere down the line by a jury, and that's a big if, because he claims self-defense. But if he is negligent, are the homeowners vicariously responsible?
Yes, they would be, because as members of the homeowners association, if Zimmerman was acting within his duty as captain of the watch program, the homeowners association is responsible for hiring him, for making sure guidelines are in place, and if he's negligent, that trickles down to the members. That's one of the, I guess, responsibilities as being a part of this association.
Joey, in tort law, there's what's known as respondeat superior. An employer is responsible for the actions of the employee that occur during the course and scope of the employment.
Right.
Here, it's not necessarily an employee, but there is an agency relationship between Zimmerman and the homeowners association. Does respondeat superior apply?
Well, respondeat superior would apply, but the question would be whether or not, still with that applying, Greg, he would be responsible. And here's my problem with it, and here's why I say it does apply, because he's acting as an agent for the homeowners authority. He's not just there by himself, right? He has a larger purpose. That being said, Greg, I have two issues here. One issue is notice, the other is foreseeability. When you look to the issue of notice, what you want to do is you want to look at the individual and see if there's anything in their background that might dictate that they might engage in an act like this, right?
Zimmerman,
because remember Zimmerman, of course, because in tort law, remember this, Greg, the risk perceived is the duty defined, and in the event that he had some prior history or conduct, it makes it more likely. That's one. The second problem I have here, Greg, is the fact that when you look at the protocol that he followed, you can argue that he violated it. Why? Because he had a weapon and he should not have had a weapon. That's number one, and the homeowners say you shouldn't. The second big thing is he pursued and he should not have pursued. So does that break the cause of change?
As I pointed out, he has to be acting during the course and scope of his authority.
Right, and
he may have exceeded that authority.
Well, even if he did, I still say the homeowners association would have liability, because there should be guidelines in place, and we don't know what their guidelines were.
Right.
You know, they're not responding to telephone calls, but they are responsible for saying you can and you can't do X, Y, and Z. And if he acted beyond that scope, there's some liability. I believe he called the police about 46 times.
Yeah.
So
well,
clearly there's something wrong.
Well, we all know.
Doesn't that put the homeowners association on notice that this guy is acting in a way that is suspect?
Well, here's the problem, Greg. It's not necessarily suspect to engage in a number of calls. He engaged in a number of calls. Now, what does that make him? It might make him a very activist person.
They're excessive, wouldn't you say?
But you have to look at those calls and you have to see what was the nature of the call and whether or not in those calls he was acting in an irresponsible way. I don't think they established that.
He violated the instructions of the 911 operator.
That's a big issue. And that shows right there that they should have known. He called the police. They told him, do not follow Trayvon Martin.
Well, I'm not sure that puts the homeowners association on notice. You'd have to be clairvoyant to know that he was violating the 911 instructions.
I think that breaks the chain of events. When you have not only the protocol that says don't follow, don't pursue, but you have the operator that says don't follow, don't pursue, and you do it anyway, I think that independent action might remove him from the homeowners association liability.
Now, look, homeowners association always have E&O coverage. Insurance coverage for errors and omission, but does that apply to the homeowners themselves or only to board directors and board members?
I believe that applies only to the board members, because, and it doesn't apply in situations like this. It may be something like someone slipped and fell on a property on the common grounds. But for a wrongful death case in this particular instance, I don't think the insurance will cover it.
Is this really different than a slip and fall?
Greg, I'll tell you though, I would agree with that. I'd agree with the assessment that at the end of the day, watch this, the homeowner's responsibility, that insurance company is not paying for that. Those owners are going to be responsible.
And what do you bet bankruptcy will not insulate them from liability?
They always try to do that, and it won't. And we know, Kisha, how much you love homeowners associations.
Oh my gosh, I just got assessed $30,000 for stucco.
For stucco?
For my office development,
Just for one individual stucco and then everybody 30,000? I could do that for 1,000 assessment per person. I'll save you some money.
We'll contract with you.
Yeah, I'm big on stucco. All right, Kisha Hebbon, Joey Jackson, thanks very
Pleasure,
much.
Greg.